This is John Watson in our continuing series on debt buyer lawsuits. I want to talk to you today about the fact that normally debt buyers do not show up at trial with any witness. And it's kind of a remarkable concept when you think about it. These debt buyers have filed a lawsuit. They know that they bear the burden of proof of showing that you owe the debt to them. And yet they show up at trial, no witness. And you think about it, if somebody filed a car wreck lawsuit and everybody shows up to court except the plaintiff. That would be very bizarre. And so we're often asked by clients, well, why do the debt buyers typically not show up for trial? And the reason is simply economics. They don't perceive a need to show up when they win so many cases on default judgment. The very few people that do answer the lawsuit, most of those resolve the case with the debt buyer by paying the debt buyer money. The ones that don't and go to trial, in our experience, about half the people who are unrepresented by a lawyer that get a trial date, so they've made it all that way to court, then they don't show up. And the plaintiff, the debt buyer, wins automatically. The ones that do show up typically go out in the hallway with the lawyer and they work out a deal, they work out a consent judgment, some kind of payment plan, and then they pay money. So there's really no reason for the debt buyer to go to the expense of flying witnesses all over the place. Some of these companies file as many, or perhaps even more, than 100,000 lawsuits a year nationwide. For example, Midland Funding here in Alabama typically files a couple hundred cases a week. You start doing the math on that and you say, well, that's 800 a month and they're 12 months and that's getting up there around 10,000 lawsuits a year just in Alabama. So it's a remarkable number of cases that these companies file, and it's just not worth it to them in the normal situation to bring a witness. So how do they prove their case if they go to trial? Well, what they are looking for is to prove their case through you. They think, I'll get you on the stand and I'll get you to admit this. And it's beyond the scope of this video to talk about how you should answer questions. With this exception, if you'll keep this in mind, you cannot, should not, must not speculate. You are there to testify, to be truthful, but you're not there to make stuff up. You're not there to guess. And so oftentimes these lawyers will say, well, don't you agree that we bought the debt? You have no way of knowing that. And here's the weird thing. They don't bring the documents to prove it. The lawyers don't even have that. When we've asked the lawyers, show us the documents, I think there's maybe been one time when a lawyer said, oh, I've got that document in my file, but I'm not going to show it to you. We don't want you to see it. Which raises a whole interesting set of issues. But normally the lawyer hasn't even seen that. And if they do bring anything, it'll typically be the first page of a document that says, we're selling these accounts, but they don't list the accounts. Your name is not on there. And so just keep that in mind, that they often do not bring witnesses. They often do not bring documents. And this all goes to putting them to the test, making them prove their case. We'll have a few more videos on this subject and this whole series of debt buyer lawsuits. We hope this has been helpful for you. If you'd like more information, we can send that to you. If you'd like to talk to us, we'll be glad to talk to you. You can call us 205-879-2447. Go to our website, alabamaconsumer.com. Or if you're watching this on our blog, quite likely there's a form that you can fill out below that will say to send you the free report we have. And of course you can call us and get the free report or fill out the form on our website, whatever's easiest for you. And we'll be glad to send that out that talks about a lot of these secrets that debt buyers don't want you to know.